Good evening, everybody. I'm your host, the Supreme Litigant, and I'd like to welcome everybody back to smartloctv. If you haven't already, please go ahead and hit that like button, hit that subscription button, turn that notification bell on, and I'll give y'all a few seconds to do that. All right, so the first thing, I just want to thank everybody who has subscribed to my channel. Thank y'all for taking the time out to watch these videos, teach yourself, and learn. Second, I'm not an attorney. Okay, I don't want to be an attorney. All right, but I do know what the hell I'm doing. All right. Third, I do make mistakes, just like everybody. So-called judges make mistakes. That's why they have appeals. So-called attorneys make mistakes. That's why they have appeals. But anyway, today I want to talk about this post that I made today and just explain it. I want to answer a few questions and just provide some commentary on it. So the post says the form of government created by the Constitution is the Republic. The form of government created by the legislature via corporate charters of municipal corporations is a democratic republic. You have free will to remain there, meaning within their corporate territorial jurisdiction, or you can leave their corporate territorial jurisdiction whenever you want. They cannot hold you there against your will, because anytime you are not free to leave whenever you want, that is an arrest, and you can sue them for that. You don't have to go to jail to be arrested. You don't have to be in a building to be arrested. You can be outside, standing on the sidewalk, in no handcuffs. But if a public servant tells you you are not free to leave, then you are arrested. Sue them for that. They can't make you stay here. They are not sovereign. All right. So let me go over here, read a few comments. Problem is they want to stalk you while you're away to the Republic. I can agree with that, William. I can agree with that. But what you have to do, this is what I've learned, because they're corporations, and corporations love so-called money. You have to make it extremely expensive for them when they do anything to you. And I mean anything to you. I don't care if they step on your shoes. I don't care if they look at you. Sue them. I don't care if you lose the lawsuit. You cost them money. All right? You got to cost these people money. All right? And I was just being a little sorry, not a little sarcastic, but a little, just trying to, I was exaggerating a little. You can't really sue them for looking at you, but you know what I mean. What I'm trying to say is, anytime they give you a lawful purpose, sue them. They do anything to you without a lawful purpose, sue them. Do not wait until the time is up to sue them. Always sue them. Well, yeah, and another thing I wanted to comment on. I've been stopped with like 8 active capias warrants before. The cop looked at me in my face and said, "You know you have 8 active warrants for the city of so and so?" I say, "No, of course I knew," but I say, "No." He says, "Well, I'm not going to do anything to you, but you need to get this fixed," so on and so forth. I've been stopped by numerous police. You don't have to do anything to go to jail no more. If I knew back then what I know now, I would have beat every single one of those lawsuits, because that's really what they are. They're suing you. That's what they're doing. Corporations have to enforce their own rights. They're filing lawsuits against you. That's what they're doing. They're telling you it's the state. No, it's a corporation called the state of whatever it is. But let's get down a little bit more. Awaken says, how does one detach without rebellion against opting out? Without forced counties upon one's land. This is not as easy as pie, is it? Yes, it is. I'm of the opinion that it is. But what you have to do, Awaken, is if you don't, I'm not sure if you do, but if you don't, you need to understand certain principles of equity. And Just so happens I have to have a treaty on equity. So what I'm going to do is I'm going to show you what I mean. All right, William, this first one is for you, okay? But this is really for everybody. And then I'm going to read the other one. All right. So this is on page 69. Let me show y'all what I'm reading first. It's on page 69. Let's go page 1. All right, so this is a treatise by Henry Gibson on equity, suits and chancery. Chancery is another word for equity. This is the jurisprudence of it. If you want this, let me know. You should be able to Google it right now. You can just type in Henry Gibson equity PDF on Google, and you should be able to pull up this same exact document. All right. This is a treatise. You will see so-called, judges citing this in their court opinions when they need guidance on how to rule on cases if there's no case law. You will see stuff like this. Let's go back to 69. All right. Equity aids the vigilant. Equity aids the vigilant, not those who sleep upon their rights. So what this means is when they violate your rights, you need to act within a reasonably timely manner. You cannot wait. But let's go ahead and read some more. I'm going to read this. I'm going to give you some commentary on it. There's a footnote right here, 46. So let's go down and see what footnote 46 says. See if it's down here. It's 45. Okay, it's going to be on the next page, is it? Okay, no, it's right here. So this is it right here, but it's in Latin. Okay, I can't really read that, but that is a principle, just to let you know. What you're seeing here is a principle. These right here, this is a principle. They're telling you do not sleep on your rights. The government and you are on equal footing. All right? They're on equal footing. You're on equal footing with the so-called government. But let me go ahead and read some of this stuff for you. This maxim is designed to promote diligence on part of the suitors, meaning those who filing suits. Equity requires a party to assert his rights in a reasonable time after he discovers that he has been wronged. A person who delays suit, not only by his negligence, makes the proof of his wrongs more difficult, but induces the other party to believe that he acquiesces in the situation. This is why when they violate your rights, if you don't do nothing, you acquiescence in it. You're okay with it. Do not sleep on your rights. We don't sleep on our rights over here. So if that's what you want to do, you need to just unsubscribe from my channel because we don't do that over here. We sue them. That's what we do over here. Get them in line. Besides, if courts allow suits to be delayed, a party may wait until an adverse witness dies. See how old this? Look how I want y'all to see this. This from like the 1800s, early 1800s or mid 1800s, and they were already thinking about this stuff then. Besides, if courts allow suits to be delayed, a party may wait until an adverse witness dies or moves away before he brings suit. A party in the wrong may be so misled by the non-action of the party wrong as do such acts and otherwise so change his situation that it would embarrass the court in granting relief. He who seeks equity must keep himself in a condition to do equity. And if, by his own delay, he is disabled from doing equity, he will be debarred, prohibited, restricted from receiving equity. It is bad faith for a party wrong to delay suit until the wrong cannot be righted without doing another wrong. Good conscience requires a party to do no act that will mislead another to his detriment, even though that other may have done him wrong. Even though that other may have done him wrong. Hence, It has been said that nothing can call a court of chancery into activity but conscience, good faith, and reasonable diligence. In many cases, equitable relief depends upon the discretion of the chancellor. Chancellor is another word for so-called judge. They don't call them judges in courts of chancery. They call them chancellors. And the lashes of the complainant is often one of the most important of the elements taken into consideration when that discretion is exercised. So in other words, when you file your bill, a bill is another word for a complaint. They don't call them bills anymore. They call everything a complaint now. So let me give y'all a little rundown on this right quick. At common law, complaints were called declarations. They don't call them declarations anymore. They call it a complaint. In equity, they call it a bill in equity. They don't call it a bill in equity anymore. They call it a complaint. In admiralty, they call it a libel. They do not call it a libel anymore. They call everything a complaint to confuse you. That's what they're doing, all right? This maxim is constantly applied where a party delays too long before he applies for an injunction or to be relieved against a fraud or seeks a specific performance of a contract or the rescission of a contract. It applies also to persons who do not inquire after being put upon inquiry, to purchasers at public sales where there are no warranties of quality or title, and to those whose duty it is to take necessary steps to perfect their rights by giving notice of an assignment to them for a non-negotiable chosen action, or by having their instruments duly registered. Equity delights in diligence and is slow to aid the slow. It not only requires clean hands and a pure heart, but also swift feet. But if the defendant has caused the complaint to sleep, he cannot complain of it, because that is inequity. That is inequitable. You cannot do that. For that would be to take advantage of his own wrong, and nobody can take advantage of their own wrong in equity. Meaning, you can't fraud nobody and take advantage of that fraud. Once it's being contended that there's been a fraud perfected on the court by some litigant who filed a suit. So let's say that you knowingly, I'm sorry, not you, but let's just say somebody in a case knowingly and intentionally misrepresented a fact that was essential to the so-called court exercising subject matter jurisdiction. So in other words, they fraudulently invoked the so-called court's subject matter jurisdiction. You can't do that. Anyway, let's go on down. All right. Now this is another one that is for everybody. All right, so let me go back to the channel right quick. All right, before I read that, I want to say this, Awaken. All right, you have to do equity, Awaken, which means you need to respect everybody's rights who are within that corporate territorial jurisdiction, so-called municipality, so-called city of, they are happy there. They don't want to leave. They don't even know that this stuff is going on. All right, they want to stay there. There is nothing you can do about that. You cannot control free will. God cannot control free will. And you just need to let them be. Leave them alone. That's it. All right, so they have every right to stay there because they want to be there. Just like you have every right to leave because you do not want to be there. You can't make them leave and they can't make you stay because that is inequitable. All right, so let's talk about this. All right, they have every right to stay there. That right that they are exercising to stay there is property. You have every right to leave there. That right that you're exercising to leave there is property. So you are to use your property. Let me show you what I'm talking about. So use your own as not to injure another. You exercise that right as not to injure. You cannot do that. Don't do that. Just leave. That's all you can do. Leave. What I would do, I would leave. I would go into a rural area, because when you go into a rural area, you got you 40 acres. You can do what you want out there. As soon as I get, this is just me personally. As soon if I purchase me so-called 40 acres, so-called purchase 40 acres, I would send cease and desist letters to any county that I reasonably believe that is exercising corporate territorial jurisdiction over that land. Why would I do that? Why would I do that? Because equity aids the vigilant and not those who sleep upon their rights. I'm gonna tell you right now, you need to automatically presume that rural area, that the county is exercising corporate territorial jurisdiction over that area. You need to just automatically assume that, and you need to find out which county it is, and you just send them a cease and desist, something like that. Put them on note. Send them. You need to send them every type of notice that you can think of, because you are doing equity. All right. And so when they come out here and they try to take your land for tax evasion or something like that, then you should be able to collaterally stop them from bringing this suit, because you tried to resolve this matter way on before it got out of hand. I don't want any benefits from you. Okay. And since I'm not taking any benefits from you, you haven't done anything to this land. Why should I be paying you taxes? Because taxes are conditioned on benefits. All right. So that's what I would do. So let's say you got you 40 acres. Okay. Everything that they doing in the city, you can do on that land. You want to build you some streets, private streets, you can do that. You can make your streets look just like the streets in the city, but they don't belong to the city. They belong to you. It's private property. You can have a private town, and there is nothing they can do about it. It's not public. It's private. It belongs to you. So let's say you want to make up you some street signs, names for your streets. You can do that. Let's say you want to make up you some house addresses, some numerical numbers for your house. You want to put you some houses out there and make up you some numbers for the houses out there. You can do that. You can put you some stores out there. You can put whatever you want out there. It's private property. It belongs to you. You are on equal footing. They can't discriminate in the public, but you can over your own private property. You have plenary power over that property. It's yours. So let's say you got some businesses out here, peeps. There's some business owners. They want to come out here or whatever, and they want to do, just do a little business out here. You say, okay, well, that's cool, that's fine, but you're going to have to pay me for it. You can do that. It's your property. It's on your land. It's in your building. It's private property. Is this making sense for y'all? You can do that. Grow your own food, open your own stores, whatever. What I would do is I would create me some sort of legal person to do business with the outside world. All right. And that business, it will be responsible for all of the taxes and so on and so forth like that or whatever. And then I would use that business, maybe some credit or something like that, to finance everything that I'm building on my land privately. That's what I would do. Something like that. I would remain completely, to the best of my abilities, anonymous as possible. I would never use a social security number ever again. Probably put everything in a trust or something like that. That's what I would do. But let me read this. This is another principle of equity. So use your own as not to injure another. While this is a law maxim, meaning a common law maxim, it is often applied in equity. Just let me stop right there. Equity governs all the jurisdictions. That means it governs common law jurisdiction, admiralty, and maritime. And obviously it governs equity. All right. It's applicable in all of them. So anytime that you reasonably believe that you have suffered an inequity, you need to be acting upon it. And you need to put the so-called court on notice. The Chancery Court frequently enforces this maxim by enjoining the erection or commission of nuances to the complainant on the land of the defendant. Because although a man may own the land, he has no right to so use it as to prevent his neighbors from enjoying their land. That is inequitable. You cannot do that. He who seeks equity, you don't want nobody to do it to you, so why are you doing it to somebody else? He who seeks equity must do equity. A man may be driven from his home by bad smell, noxious vapors, unbearable noises, shocking spectacles, and other intolerable nuances upon his neighbor's land, quite as effectively as though driven away by physical force. A man cannot so divert a stream of his own land as to turn water injuriously upon a neighbor's land, and he cannot dig so near the land of his neighbor as to cause the latter land to cave in, or so near as to endanger his neighbor's wall. He cannot pollute a stream that flows through his neighbor's land, nor can he so stop or change the current of a stream as to prevent its ordinary flow through the land of another. A creditor, having his choice of two funds, ought to exercise his right of, I'm guessing election, in such a manner as not to injure injure other creditors, who can resort to only one of these funds. And it may be laid down as a general rule that no one can so exercise a right as to impair the right of another. You can't do that. This is what I was talking about, Waken. You got to leave them alone, fam. Ain't nothing you can do. Just leave. You have to just leave and go live your own life. They have every right to be there. Nobody is keeping them there. If they won't accept the benefits and privileges and pay the taxes on it, they have every right to do that if that's what they want to do. And you just need to be respectful of that. That's all you can do. And it may be laid down as a general rule that no one can so exercise a right as to impair the right of another, especially if the latter right is of equal dignity in the sight of the law. You have the same right. So there's nothing you can do. These rights are equal. There's nothing you can do. The rights of life, liberty, property, and the pursuit of happiness must all be so used and exercised as not to impair or injure the equal enjoyment of these rights by another. The Chancery Court will, on due application, enjoin the defendant from using his property or so exercising a right as to injure the property or rights of a complainant. There's nothing you can do. There's nothing you can do about it. You got to leave them alone and let them stay there. That's where they want to be at. Let them stay there. But you can leave. They can't force you to stay there. And if they do, you need to sue them. You need to make it extremely expensive when they mess with you. Geneva Convention card, ask for it if they take you in custody or kidnap. Two different jurisdictions. One is a country, the other a corporation. Yeah, I'm gonna see if I can give you an example of. Okay, I think I got the perfect one. I'm gonna use the District of Columbia as an example. Let's go to Google. District of Columbia map. All right, let's go to the images. All right, right here. So this is generally how this works. I'm gonna pull this up, see if I can make it. I can't make it bigger. Let me get it a little bigger than this. Give me a second. Let me pause the video. I gotta make it bigger. I'll be right back. All right. So what I'm gonna do is I'm gonna use this as an example. and we're just going to be talking about various cities. So let's say everything within this box right here is, it says the District of Columbia. So we'll start off with the District of Columbia. Okay. So that means the government for the District of Columbia essentially controls everything within this corporate territorial jurisdiction right here. This is theirs. All of this is theirs. They pretty much have plenary power over all this stuff. Okay. And everything outside of this, they have zero control over. All right. Now let's say we are in the city of, let's say in this box, this is the city of Atlanta. All right. So the council for the city of Atlanta can exercise corporate territorial jurisdiction over everything within this box right here. And anything outside of this box is without. It is not within, it is without their corporate territorial jurisdiction. It is outside. It is beyond. It is not near. It is not, it's nowhere in it, their corporate territorial jurisdiction, which means that their bylaws, which they call ordinances, do not apply. Or if you want to get a little technical more with it, let's say that this is the state of Georgia, so to speak, or whatever, and this is the legislature right here. All right. So statutes would only apply to everything within this box, and everything out of that box, it is without the jurisdiction of the legislature, meaning they don't have jurisdiction over it. They don't have authority over it. They don't have plenary power over it. They can't do anything to it. So what you need to do is you need to get out the box. All right, you need to get out the box. Now, when you go to a county somewhere, like I said, I'm about 99 to 100% for sure that there is a county that is going to be exercising corporate territorial jurisdiction over that rural area. You need to put them on notice that, hey, look, I don't want your benefits. I don't want none of your privileges. I'm good. You're not going to take care of this land on my own. Cease and desist. I appreciate the offer, but no thanks. Something like that. Who cares if they don't? I don't care if they ignore it. You have a duty to respond to this. I'm telling you, don't come out here. It's private property. I'm placing you on notice. If you come out here, you're going to get sued. I am outside of your corporate territorial jurisdiction. And just because you are outside of their corporate territorial jurisdiction does not mean you can do as you please, because you are still bound by this rule right here. This is equity. You cannot do what you want to do. You need to treat people the way you want to be treated. You're still bound to this rule right here. So use your own as not to injure another. Even if there were no statutes requiring speed limits, and if it became a problem, obviously the chancellors would equitably step in and fashion a rule for this, because there's always a remedy in equity. They would come in and they would, fashion a rule for it. As a matter of fact, there are old cases way before that I've seen even in statutes that's telling people you have to use the roads in a reasonable manner. You cannot do whatever you want unless you're doing it in a manner that is not going to injure or impair the rights of somebody else. That is the only way you can do that. It's the only way. That's it. So let me see. I think there was another question I had on here in regards to, I think it was the child support. Got to see if I can find it. Somebody asked me, could they use that in, I think they asked me, could they use it in Illinois? That ebook on the child support thing, that is a principle. They've been knew about that. The remedy is in equity. It's in equity. That's where the remedy is. They've been knew about that, man. Yes, you can use that in Illinois. If you're watching this video, I'm not sure which video it's on, but yes, you can use that in and you can use it anywhere. They're not gonna tell you're probably not gonna see it in the statutes in the state, so-called or whatever, because they modified it. So what they do is anytime a rule is fashioned by a chancellor or somebody of an actual judge, an actual Article so-called 3 judge or whatever, in other words, a judge that is created by the people, anytime they come up with a rule, what the legislature does is they will adopt that rule from the jurisdiction of common law or equity, and then they will bring that rule over into their territorial administrative agencies, and they will promulgate that rule, or in other words, exhibit or show or declare via their code that rule. But what they'll do is, if they don't like something that the chancellor or the judge said in the common law court or the equity court, they'll modify it, they'll take it out, and they will not authorize their executive administrators to do stuff like that. They'll just leave it out. They're hiding this stuff. They've been known about this stuff. All right, I got a little free time, so I might do a live or two. I got to start back working on this brief because we just got their answer back. I mean, we just got their reply back, their response, and we about to give them a reply soon. We got about 3 weeks to give them a reply, and I'm still waiting to hear back from the Court of Civil Appeals in my case. So I'm getting ready. I'm kind of just thinking they're going to rule against me. So I'm already starting to work on my petition for a writ of certiorari. But anyway, I hope this answered y'all questions. If not, let me know, and when I get some time, I'll come back and answer. That'll be the end of this video. The Supreme Litigant is out. Peace.